Please don't follow Mr. Gallison and take longer than 5 minutes.
I'm going to... I gave you a great deal of material, Senator, so I'll try to just hit right to the points.
Hit the points. That's what I want the witnesses to do. Let's hit the points, the issues that you have, and maybe any recommendations that you may want to see.
Certainly.
Okay.
Perhaps I could answer a question that you raised earlier, that what can we do with the SCJC? And it's a very simple answer.
Everybody know what the SCJC is.
State Commission on Judicial Conduct. The answer is very simple. You just have to make it public. And you're mandated to do so, and I'll explain why. Article 6, Section 22 of the Constitution of the State of New York states, the State Commission on Judicial Conduct is the disciplinary agency constitutionally designated to review complaints of judicial misconduct in New York State. The legislature presently has abrogated its constitutional responsibility by giving a constitutional obligation to an organization that is not subject to review or oversight. As a result, Section 44 of the Judiciary Law violates the Equal Protection Due Process Clause of the United States Constitution. That was the basis of my federal case that I filed in Southern District. Both attempts of trying to file that case were dismissed, first by the Honorable Griesa, where I couldn't even file a complaint because he coached the Attorney General what to do in order to get that case dismissed. The second was Honorable Scheindlin. My case was consolidated with hers. That also was because it was sua sponte dismissed, where I couldn't file a complaint. This is the issue. This is the answer. And the federal court does not want to address it. Based upon those dismissals where I couldn't even file a federal complaint, and if you look at the transcript, which is next to the materials I sent to you, of which these are in Judge Griesa's words, where he coaches the Attorney General on what to do to get this thing dismissed, and the unusual ruling by a federal Judge Scheindlin to sua sponte dismiss a complaint, which is against prevailing Second Circuit case law because it doesn't even give an adversary the capability of opposing it. This is the issue they don't want to address, but this is what you can address. This is what you can fix. This is what you can cure. And I'll tell you what the overall problem with this is. By not making it public, what you're doing is allowing the rigging of the election system in the state. By the State Commission on Judicial Conduct not turning over these complaints to the screening committees who screen the judges, what you've done is rig these elections. Nothing more complicated than that. And this is what they're trying to preserve. They want these elections rigged so they can put the people into power that they want to be put in power. And it's unconstitutional what they've done, and that's a simple thing that you can do right now, which two federal judges do not want to address, that this legislature can do. Secondly, the Uniform Judicial Questionnaire is hidden under a veil of confidentiality by the OCA. Board of Election controls the election process with any of the politicians in this state, but not with the judges. They keep it secret. They keep it under a veil of secrecy. And by doing so, you're not giving the capability of the public to look carefully at these responses, look at the resumes of these judges to see whether or not they're making false statements. Now, the reason why I bring this up, and it's a big issue, is because Judge Sotomayor right now is being judged. And if you look on the judicial webpage of the Senate Judiciary Committee in Washington, you'll see her answers to her judicial questionnaires. You will also see her transcripts that when she was nominated in the past of what her responses were, so that the public can go ahead and view it. Why should this state deserve anything less? Now, the reason I mention all of this is it's also very important to do it because Section 17-128 of the election law says that a public officer who willfully omits, refuses, or neglects to perform any of its duties by hindering or delaying to hinder the delay or the performance is guilty of a felony. So when you have administrative judges who are not being truthful to the screening committees when they're asked, are any complaints being filed against these judges who are now seeking an elected post, they run afoul of this. because that questioning is done by an informal process where a screener calls the judge up over the phone, of which they can say anything or conceal anything. It's not done under oath, under the penalty of perjury, with a court reporter in the room. Because I have boxes of letters that I had sent to the administrative judges concerning missing court files, clear violation of contempt of executive orders by the governor after September 11th that were summarily dismissed by the State Commission on Judicial Conduct. Now, dealing with the First Department Disciplinary Committee, I have to tell you a little story, if you would mind just a minute, and then perhaps you can understand what the gist of this is. Many years ago, I hired an attorney to represent me in a dispute, and I believe he charged me an excessive fee. He files a lawsuit to recover his fee, and I hire another attorney to represent me. His name was Howard Benjamin. Mr. Benjamin doesn't go to court, and Mr. Calabro obtains a default judgment against me. When I requested Benjamin to vacate the default, he claimed he could not because he made a false statement to the court about having been on jury duty at the time of the court appearance, but instead was in his office. Benjamin informed me he was going to pay the judgment to avoid the ramifications of explaining it to the court. Years later, my credit was seriously affected since Calabro's judgment had not been paid unknowingly to me. Neither Calabro nor Benjamin was helpful in giving me copies of the alleged checks that Benjamin had paid Calabro, which was damaging my credit score. Without recourse, I filed a complaint with the First Department DDC. Since by law, if Benjamin had paid Calabro, then Calabro and Benjamin were required to hold on to these checks for a period of 7 years. The First Department DDC transferred the case to the Fourth Department DDC since Howard Benjamin was an attorney who worked there at the First Department DDC, and his partner, Mike Gentile, was the former chief counsel at the First Department DDC. At the Fourth Department DDC, my case was closed without an investigation as to the whereabouts of those checks and the investigation of Benjamin's false statements to the court. I brought the complaint to the former presiding justice of the Fourth Department DDC, the Honorable Piggott, who now sits on the Court of Appeals. He did nothing. He concealed it, he covered it up, he let it go. I filed again in the First Department DDC to have Sherry Cohen and Sarah Jo Hamilton tell me for years that they were retrieving these checks from the bank, of which I've given you correspondence documenting all of that. Then I received a letter dated November 8, 2004, 3 years after I requested the ghost copies of checks, in which Thomas Cahill, chief counsel of the DDC, states, quote, in fact, after you filed your complaint, Mr. Benjamin provided the committee with copies of the fronts of 2 checks and a copy of the front and back of another, as well as the corresponding transmittal letter to Mr. Calabro. You have those letters. During this period of time where I could not obtain copies of these checks, I wrote boxes of letters, I mean boxes, to the Honorable John Buckley, who was the presiding justice at the time, to the Honorable Judith Kay, who was the chief judge. They were the administrators. They were supposed to deal with something. They did nothing. They concealed it. They covered up. They did absolutely nothing. There is no administration of this court system. That is what the problem is. And I can tell you, I called up Chief Judge Kay's office many a time and spoke to Mary Moan, her counsel, and her response was, the judge is a sitting judge. She's not an administrative judge. I said, well, what do you want me to do? She's the one that has this duty. But she refuses to live up to her responsibilities. That is the problem. But to go back to the court, during the time when I could not find these checks, get these checks, I filed a complaint against Mr. Calabro under the Fair Credit Reporting Act in an attempt to obtain copies with him. Honorable Joan Kenney publishes a decision on the front page of the Law Journal in which she says, I have 35 lawsuits against as a pro se litigant. Then she says in another transcript, when I rendered the decision in the other case a year ago, I did my own research. And she, at that point, commenced in excess of 75 actions. First of all, a judge cannot do their own research. They cannot go outside the record. Number 2, she makes things up and was lying. Now, how did this judge get on this bench? It's very interesting that how could she freely do it and be allowed to do it, because I filed a complaint with the State Commission on Judicial Conduct and they summarily dismissed it. my federal complaint was seen by someone who was in this room who happened to be a certified fraud examiner and was also at the brunt end of the misconduct and allegations by Joan Kenney. And she went ahead and obtained the curriculum vitae of Joan Kenney when she ran for election. She found material misrepresentation in her campaign website. The official site provided inaccurate and false information about the candidate's participation in law school activities, such as law review, the candidate's licensure date, legal employment, and professional experience. I have no personal knowledge of the investigation, but I brought her here that if you want to question her concerning this, she's sitting in this audience right now. But this would not have been allowed to happen if that unified judicial questionnaire would be able to be made public. That judge would not be sitting on the back freely going ahead and saying, I have 35 lawsuits and 75 lawsuits and whatever she can come up with and going outside the record. But this leads to an important point because based upon that decision, the Honorable Deborah James, in a case where I brought because of some legal malpractice where I hired an attorney to represent me, says that I have put a protective order prohibiting me from initiating any further litigation as a party plaintiff without prior approval of the administrative judge of the court. This also gets published on the front page of the Law Journal, claiming that I'm frivolous and repetitive actions or vexatious conduct, which is based on Judge Kenney's decision, which she makes up.
Could you sum it up?
Yes, we've got more, though. If you want crimes, I'll give you crimes right now in what's in that paper to get a special prosecutor, not only at the DDC, but at the State Commission on Judicial Conduct.
And I will it's in here. I will definitely follow it up, but if you can.
Okay, I'll wrap it up in about 5 more sentences. I appeal the decision in Judge Kansas' case into the Appellate Division. Who sits on the panel? Judge Buckley. What does Judge Buckley do? He doesn't recuse himself. I make a motion for his recusal. He refuses. Then I make a motion to re-argue, get a whole other 5 judges that are sitting on the panel there. Judge Friedman, Tom, Costa, and Helen Friedman and David Friedman, and they both agree that he doesn't have to recuse himself. So there is certainly the basis for his recusal because he has a vested interest in the dismissal of that case because it has to deal with the federal complaint, which I put it a part of. Further, I have a judgment against me for over $250,000 that was put on a landlord-tenant dispute. In terms of me trying to perfect the appeal, of which the case law was in my favor and the judgment should not have occurred, the file in the county clerk was completely destroyed. I sent a secretary down there to copy it for the purpose of getting the record. She was given initially 5 files, 6 files closed. The next 2 days, she was given 5 files. Then it turned out to be 4 files, to the point where I couldn't even perfect the appeal concerning that. I asked the Appellate Division to help me reconstruct the file. They refused. You want retaliation? This is what happens when an attorney opens their mouth and complains about violations of executive orders, missing court files in a courthouse. If you want every attorney sitting in this room and out the door, I could have you thousands if you give them protection. What you need to do is give them a registration with an anonymous number, and anytime they see misconduct, corruption by a judge, to anonymously report it and to be taken seriously. Believe me, the attorneys in this, I'm probably one of the few attorneys here. There would be many more if you would give them that level of protection, and this would stop. And the people of this state would be well served by finally get some justice into this state. Oh, can I make one more point? One more point.
We have to.
No. I'll be 30 seconds, I promise you, because this one you can't let go of. On November 22nd, 2008, I write a letter to the DDC. Alan Friedberg charges me because he chose to start an action against me because a locksmith who repaired some locks in my office, I disputed the bill and he filed a complaint against me. A bill, not even attorney services, while on other cases I know of where lawyers are practicing law, unauthorized to practice law in New Jersey, he doesn't even file the complaints. I also have in there.
30 seconds out.
All right.
Ms.
There's
Caporaso,
more.
thank you. Noah, thank you very much, but we'll follow up. Thank
All
you.
right. Follow.
Thank you very